So I'll continue now with the Reagan Revolution. And it's interesting, especially for the question of constitutional politics and the status of the judiciary, because it's not so clear what the significance of the Reagan presidency is. It was clearly a major political shift and a major political moment. At the time, people thought it might be really the displacement of one regime with another, the New Deal era being replaced by the Reagan era. And what has seemed to happen, or at least in my view what seems to happen, is you have two opposed understandings of American constitutionalism cohabitating in the same political space. Reaganism articulated an alternative vision of what the Constitution means. It rejected or pushed back on the bureaucratic regulatory state. It tried to strengthen federalism. It tried to limit national power. At the same time, it also tried to push back or resist further expansion, at least, of some of the civil rights decisions of the Warren Court era, particularly involving religion and sexual privacy. To a lesser extent, it was trying to limit the expansion of civil rights for African Americans as opposed to push back the expansion of those rights. But as I said, and this may explain the fuel in the culture wars and the fuel in the battles about constitutional nominations in the court, we have two different worldviews cohabitating in the same political space. People haven't rejected the New Deal. At the same time, people haven't rejected President Reagan's vision of American constitutional politics either. And so I think that is, in broad terms, is what we're looking at today. If you wanted to think about this in terms of constitutional cases, the sexual privacy cases are clearly in the news. People think Roe versus Wade is possibly or likely to be overturned now that Donald Trump can add another conservative to the conservative appointments of the two President Bushes. With the resignation of Anthony Kennedy, Ronald Reagan doesn't even have a justice on the Supreme Court anymore. You also see this in cases like the one about Obamacare, where the court came pretty close to holding that Congress couldn't pass Obamacare consistent with its powers under the Commerce Clause, which would be a fairly radical pushback in terms of enumeration and federalism. Enumeration in terms of its limiting what power Congress can claim under the Commerce Clause, and in terms of federalism because it allows a lot of power to shift to the states if Congress is pushed out of that sphere. And so in a way we can think of that as the federalism ideas of the Reagan era, the anti-regulatory ideas of the Reagan era, because presumably when you push authority to the states, at least many states will have an anti-regulatory bias simply because they're red states. It'll be interesting to see, should that ever happen, how the court would respond to regulations in the blue states. I mean, you may go back to something like a Lochner jurisprudence where you use rights to combat state regulation and you use federalism principles to combat national regulation. But that's highly speculative, and it's hard to imagine that happening for a number of reasons. Most notably, one of the reasons the New Deal has power in terms of hanging on in terms of some of our consciousnesses and how we think of ourselves politically, and why the New Deal era is still with us, is because many people like a number of the policies, even if they reject the idea of big government in principle. But anyway, I was more concerned for this lecture to talk about how these broader themes play out in the politics of judicial nominations. Now, one of the things that happened early in the Reagan era, and this was something no one noticed at the time, and it really didn't come into full bloom in terms of its influence until relatively recently, but there was something that was created in law schools. I think it was created at Yale Law School, but it was a number of law schools that were associated with what's called the Federalist Society. And what the Federalist Society was originally a student organization that grew to include conservative law professors and conservative judges to create what you might think of as an alternative network for formulating and transmitting a conservative judicial ideology and a conservative understanding of the Constitution that was an alternative to what was really the dominant liberal view that tends to be represented then and even today in the law schools. Law school academics tend to be more liberal than the society in general, and even academics in some other disciplines such as political science or economics, which are disciplines that are very important in American politics. The Federalist Society becomes an alternative source for both education and promotion of a view and an exchange of ideas, and it's had great influence in American constitutional politics. We'll come to see that I think all, but most, if not all, of the conservatives on the court, and certainly who will constitute a conservative majority if President Trump's second nomination, Brett Kavanaugh, if that gets approved, have fairly strong ties to the Federalist Society. But again, the evolution in this area took a while. It didn't just happen in the 80s with Ronald Reagan. It was a slow process with fits and starts. Reagan's initial appointment to the Supreme Court, Sandra Day O'Connor, was motivated primarily by a desire to put the first woman on the Supreme Court. And he chose somebody who was relatively non-controversial. She was, again, what then would be thought of as a conservative, but a moderate, more traditional Republican conservative, very much like Lewis Powell. Now, that was the only appointment President Reagan had in his first term. And from the perspective of constitutional politics, his first term was comparatively quiet, but around the beginning of the second term, you start to have an explosion of change. He has two nominations in particular. The first was Chief Justice Burger resigned, and President Reagan appointed Justice Rehnquist to become Chief Justice. And then to fill Justice Rehnquist's seat, he added Justice Scalia, who really becomes the exemplary of what a conservative justice is for us today. I mean, he becomes the main voice, the main symbol of conservative judicial politics, as we saw when we talked about originalism. Now, Justice Scalia, at the time, was not a conservative appointment. He was a conservative appointment. He wasn't a controversial appointment. He was recognized as conservative, but constitutional politics wasn't as partisan, and it was less concerned with the substance of the decisions then, for a number of reasons. And so, because Justice Scalia hadn't done anything particularly controversial, his appointment was approved with near unanimity. A second reason that happened was because Justice Scalia basically was an appointment who replaced a conservative with a conservative. But the next appointment really was an earthquake in American constitutional politics. A year or two after Justice Scalia was appointed, I think it was a year later, I think it was in the summer of 87, where Scalia was an 86 appointment, Justice Powell, who we talked about last time with moderate from the Nixon era, he resigned, and President Reagan nominated Justice Bork, or Judge Bork, Robert Bork, to replace him. Robert Bork was controversial for a number of reasons. He was a controversial political figure because he was involved in the Saturday Night Massacre in the Nixon White House, and he was actually a Solicitor General, I think. He might have been an Assistant Attorney General, but I think he was a Solicitor General who ended up being the one who fired everybody and carrying out President Nixon's order, and that, I think, resonated and made Judge Bork a target where he might not otherwise have been as big a target, and certainly a bigger target than Scalia. But beyond that, he was much more political and public in his writings, and so Judge Bork created a pretty clear record of what he would do on the Supreme Court, and he was replacing Powell, so he was going to be swing voter. And so the Democrats in the Senate particularly organized a fight against him, which really becomes a model for how constitutional politics are fought on nominations on both sides. By both sides, Republicans and Democrats do it, and they do it on both sides in terms of preparing nominations to get them through the Senate, and also in terms of attacking nominations to prevent them from getting through the Senate. Now, the Democrats successfully waged a campaign to defeat Judge Bork's nomination, and he didn't get to the Supreme Court. Ronald Reagan appointed a second person to the court, Douglas Ginsburg, whose nomination also failed, but his failed for, I think, more personal reasons. There were certain rumors and stories about him relating to his behavior as a law professor, and his nomination didn't get approved either. And I think he still remains a circuit court judge in the Midwest, but he may have finally retired by now. But the third appointment to that seat was Judge Kennedy, who becomes Justice Kennedy. And Judge Kennedy is incredibly important, in subsequent constitutional development. The reason is he replaces Judge Powell as a swing voter. Now, at the time, people thought he would be more conservative than he ended up being. And if you look at the Rehnquist Court, which is the court that replaces, it doesn't really replace the Burger Court, it's the court that the Burger Court grows into, you'll find that, at the time at least, the Burger Court was, the Rehnquist Court was unique in that it was one of the more active courts, if not the most activist court, in American constitutional history. And the reason why it was so active is that it made activist judgments on both the right and the left. There were federalism decisions where Justice Kennedy joined the conservatives, and there were opinions about gay rights and a revision of the abortion decision, Roe versus Wade, as law becomes replaced by Casey, which still protects abortion rights but with different kinds of criteria and slightly more restrictive criteria. But that would be an example of activism on the left. Today, people would view Kennedy, in retrospect, as a conservative, particularly on issues like business, related to labor, to a lesser extent on government regulation, but on certain social issues, he was viewed as a liberal, and his appointment, in retrospect, because of that, upset a lot of conservatives, and they didn't want the Blackmun effect to happen, the Kennedy effect to happen, particularly on an issue like abortion, which is very important to social conservatives at least. Kennedy was Reagan's last appointment, but President Reagan was succeeded by the first President Bush, George H.W. Bush, and he placed two people on the court. One fit the conservative model very nicely, Justice Thomas, who's still on the court, and the second one, Justice Souter, was, again, more of a traditional Republican, and he disappointed Republicans greatly. What happens is he joins Justice Kennedy and Justice O'Connor as the swing voters on the early Rehnquist court, or really for a lot of the Rehnquist court. The Souter doesn't stay on for that long. And they moderate a court that would have otherwise been much more conservative. And I think conservatives from this point in time learn the lesson of really vetting judges and really insisting on what might be called ideological purity to conservative judicial principles. You'll see this when we get to the appointments of George W. Bush. In terms of the law at the time, as I said, you get a mixed bag of activism. And what you also get, which is interesting, is the cases I talked about a few weeks back on the second attempt to push back on federalism. There are opinions where the court suggests it wants to limit federal regulations. It seems to take the Commerce Clause more seriously and enumeration more seriously. But it was a revolution that never really comes to pass. They never really push back. They just, on extreme cases where there were state regulatory authorities in place, they seem to draw a line to say that the federal government can't cross this line when trying to use power under the Commerce Clause. But then we move into the next era of Republican appointments with George W. Bush and then Ronald Reagan. And it's at this point you see the Federalist Society and conservative judicial politics really learning the lessons of the past, where there are no more Souters, there are no more Blackmans, there even are no more Kennedys. You see this most interestingly in one of President Bush's, George W. Bush's nominations. He tried to raise one of his lawyers, Harriet Miers, to the court, and she seemed to be very conservative. Her record wasn't as clear as some other people's records, but she seemed to be pretty conservative, but she wasn't well known and wasn't trusted, and her nomination ended up being killed not by the Democrats but by the Republicans. There was an opening that the Republicans used, and they pushed her out so that you would get Justice Alito instead. President Bush also was able to nominate John Roberts to be the Chief Justice who replaces Chief Justice Rehnquist. And with those two nominations, you really get a cementing of the conservative bloc. Each of them replaced conservative justices, so the ideology of the early Roberts court was pretty much identical to the later Rehnquist court. But then when you come to the sudden death and the appointment of Judge Garland to replace Justice Scalia died, and Judge Garland was appointed by President Obama to replace him, but his nomination was never considered, in part because conservatives in the Senate recognized that with that switch, you would have not a Democratic majority, but a liberal majority. And they fought tooth and nail against that, and were able to successfully turn Justice Scalia into the appointment of Justice Gorsuch instead of the appointment of Judge Garland, or Judge Gorsuch, who becomes Justice Gorsuch. And with that appointment, they maintained the same ideological balance on the Roberts court that previously existed. But now with the resignation of Justice Kennedy, you have an appointment, Judge Kavanaugh, for a seat that's the critical balance. It was the same seat that was fought about in 1988 or 87 when Judge Bork was appointed to it, And it even generated some controversy when Judge Powell was appointed to it in 1971, 1972. But now we know it's the swing vote, and what that means is there's 4 judges voting as a conservative bloc on the Supreme Court and 4 as a liberal bloc. And so to the extent that the justices vote in a partisan way, this vote will swing those decisions. And the evidence indicates that should Justice Kavanaugh's nomination get through, and there also seems to be a decent likelihood it would, given the fact that during the Judge Gorsuch hearings, the Republicans in the Senate reduced the ability of Democrats to filibuster nominations. And so those two variables together illustrate, one, how important these nominations are to Republicans and how they view the Constitution, and two, the potential for a major victory in terms of advancing conservative judicial ideology and a conservative vision of the Constitution. And it's plausible to think that we could see significant pushback on things like federalism and enumeration through a different interpretation of the Commerce Clause if we take the decision that almost was in the Obamacare case as a model. Now, Chief Justice Roberts is still on the court, and I don't know that he would be likely to switch his opinion on that, but now he'll be in a terrain that's more welcoming of that. In addition to that, you have the culture war cases involving gay rights and abortion rights, and we could see some pushback or maybe even a reduction of the rights that have been previously articulated. In the case of abortion, it looks quite likely, actually. You never know until the justices actually act. That's what the lessons of Justice Souter and Justice Blackmun tell us. But the Republicans have become very good at anticipating and not allowing justices whose ideology is in doubt to get to the Supreme Court. So we'll see what happens. In the next week's lecture, I'm going to talk about the same issue, but in terms of how the court influences constitutional politics, and the extent that just by having 5 justices on the court, is it really possible to just radically change the way we understand ourselves constitutionally and what the Constitution means. But I'll leave that for next week and talk to you then.